Good afternoon, everyone. I am Ayushi Tiwari. I apologize for the delays due to technical difficulties that the participants were facing, but we are capable of starting now. On behalf of the Debate and Discussion Committee at Dr. Ram Manohar Lohia National Law University, we welcome you all to the first edition of the Alternative Debate, our flagship event which seeks to combine parliamentary debating and legal discourse. The idea of alternative debate is to invite seasoned legal professionals prolific in a particular field of law to debate on contemporary issues, thereby providing the audience with rich insights stemming from their industry experience. The format which we shall be following divides the House into two sides: side government, which is for the motion, and side opposition, which is against the motion. Further, side government has two teams, opening government and closing government, and similarly on side opposition, there will be opening opposition and closing opposition. At the end of the debate, we shall be releasing a poll for the audience to tell us if the substantive speeches they heard in the debate were able to change their views on the topic. I request the audience to stay with us till the end of the debate. We shall also be opening the floor for questions addressed to the debaters. I also request you to name the debaters specifically to whom the question is addressed so that it is a seamless experience for us to pass on the questions and for them to answer it. The participants are currently in their breakout rooms and they shall be with us shortly. I request you to please bear with us for another 5 to 10 minutes, and as soon as the participants join the main meeting, we shall begin the debate. Thank you. As you all can see, the motion for the debate is on the screen. If you haven't read it, it is also available in the WhatsApp group all the attendees are a part of. And we shall also be displaying the motion and context throughout the meeting. I request the attendees who are not debating to please switch off their cameras. In the meantime, while the participants are preparing their speeches for the debate that is going to transpire, I would take this opportunity to extend a warm welcome to the people who have made the maiden edition possible by their faith in us, which is our esteemed participants. In addition to that, we also have Mr. Sumant Batra with us, who is here to better contextualize the motion in light of the ongoing scenarios in India. Mr. Batra's name is synonymous with the development of insolvency laws in our country. He is a corporate and policy lawyer of global eminence. Mr. Batra is currently the managing partner of Ketwal Das B and Associates, a full-service commercial and litigation law firm operating in South Asia. Mr. Batra was the founder manager of this firm till November 2011. He is also a senior international consultant to the International Monetary Fund, the World Bank Group, and the OECD, and has worked extensively on policy matters in Africa, Eastern Europe, Middle East, and South Asia. He is also rated as India's #1 insolvency lawyer by Legal 500, and his contributions to reforms in the Indian insolvency system are well recognized. Mr. Batra has held leadership positions in various prestigious multilateral global organizations, and he is immediate past president of Insol International. Mr. Batra also frequents various international and domestic conferences, and we are privileged to have him with us today. I request Mr. Batra to please take the stage and contextualize the motion for our audience to understand it a little better.
Thank you, Aishi. I was waiting for someone to unmute me. So, would you want me to wait till the participants join us, or do you want me to go ahead?
So you may start with the contextualization since the audience are waiting and they want to know more about the motion, and the participants can join in the meanwhile.
All right. All right. So therefore, I'll keep it a little short because I know that you people are running a little behind schedule, and I just don't want to stand in the way of your audience waiting for the participants to start the debate. So let me first of all start by congratulating RML NLU for taking this initiative and for this inaugural event of the debate. And I think this is an excellent idea to sort of bring in industry experts or practitioners to come and speak with the students so that they have a more on-ground, real-time understanding of how the law is, besides, of course, what they get to learn in the college as far as the theory of the law is concerned. Now, this is not for the first time that the world is witnessing an economic crisis. This is also not the first economic crisis, at least my generation has witnessed, although, of course, at your age, I'm sure most of the students have only read about them. And some may have also sort of seen the, if I may say, the sunset of Lehman Brothers insolvency, if not the prime, if not the Lehman in its prime, starting from 2008 of September. Uh, so as I said, for our generation, we have seen economic crisis, and we have seen how the economic crisis have shaped the the development of the insolvency law. But generations before us have seen much more, in as much as that there were economic crises which have really shaped insolvency law into, or at least started the shaping of the insolvency law into what we see today as a full-fledged product operating in the market, in particular in the sophisticated economies. And it all started with the Great Recession of the late 1920s, early 30s, when the US experienced an immense recession, which was unheard of, unseen of, and uh, even today, when you read about that, it scares you because this is the kind of aftermath it left in terms of food hunger, in terms of lack of employment, in terms of job lost, in terms of just demolishing the economies around the world. It was just phenomenal, and makes you shiver in that sense. But that was a time when also the world saw an opportunity to introduce a number of economic reforms. And insolvency reforms, in a way, saw for the first time the seeds of modernization of insolvency law being sown, with the US sort of introducing the concept of a standstill on the creditor's rights, because foreclosure was something which was taken as granted in the event of a default, but the US courts intervened and allowed the lenders to hold their hands even though they had taken a foreclosure. And then, of course, we had a second crisis in the shape of 1970s economic crisis triggered by a stock exchange event. And that led to a series of uh, economic issues around the world, in particular between US and in Europe. And that was the time again when US took the lead and introduced a number of economic reforms, equal legal reforms, if I may say. And the US, in fact, uh, took a leap of faith at that point in time and introduced Chapter 11 in the US Bankruptcy Code, which sort of gave birth to the debtor in possession concept, which is one of the most popular ways of restructuring today. As you know, that Chapter 11 in the US Bankruptcy Code, the debtor in possession insolvency regime, is considered to be one of the most popular and attractive restructuring regimes in the world. And that all started with, again, policymakers making a choice in the time of economic crisis. And then, of course, we saw the UK setting up a Cox committee, and that was all as an aftermath of, again, reconstructing the economy as a part of the rebuilding of the nation after the World War II, and the oil crisis that happened in the late 60s, early 70s, when the Koch committee was set up, and that Koch committee ultimately led to what we see in the UK law today, which was followed by most of the Commonwealth countries and even by India in 2016, the creditors and control regime, which came in the form of the UK regime, pursuant to the Koch committee's recommendations being accepted in the insolvency law of UK. And then, of course, we saw the Asian financial crisis in the late 90s. Now, that offered an opportunity to the policymakers to, again, take a major shift when we saw a greater focus on asset reconstruction. And that was a time when the concept of setting up asset reconstruction companies was conceived. Mostly state-owned enterprises, which were converted into asset reconstruction companies. Indonesia, Malaysia, Thailand, and Korea. These were the four countries which experimented with this. And of course, because Asian financial crisis led to a global impact on the economic downslide, because the trigger point for Asian financial crisis was the Asia pulp and paper enterprise based out of Indonesia, but it had investors from around the world, suppliers and vendors and lenders around the world. And therefore, its tremors were felt around the world. And therefore, it also provided a greater impetus to the cross-border insolvency review. And then, of course, we had the Lehman Brothers in 2008, and that led to a greater focus on the improvement in the insolvencies of non-bank companies, non-banking financial institutions. And we have still been seeing all that happening and unfolding since then in the last about 12 years or so. And then you had this COVID-19 creating another economic crisis. So the point I'm trying to make is that in all times of crisis, whether resulting from economic crisis or whether they leading to economic crisis, they have always come forward to meet the challenges. And insolvency reform has been at the center stage of policymakers' attention. And it was not expected to be any different in the times of COVID-19. And that is why we have seen that around the world, the policymakers have stepped in to introduce a number of measures. And one of them, which India has taken, is subject matter of debate today. And we'll get to see how these participants who will be donning the hats of policymakers, parliamentarians, are going to defend or question this key decision that has been taken of providing a moratorium on filing fresh insolvency cases. While the Indian market has accepted it quite quietly, this particular policy measure, but there had been a lot of debate, at least till such time the bill had not been introduced to the parliament. When the ordinance came, or when the policy statements were made, it was not very sure as to what is going to happen because NCLTs were closed at that point in time, so we didn't know any which was no filing could have been done at that point in time. But when the registries start opening, then obviously everybody wanted to know what those policy statements that had been made are going to translate into in terms of the legal pronouncement. And then we saw what we will be listening to today. But a lot had happened between the interim period of the announcements and the actual law being passed. There was a huge debate as to whether this is justified, whether this is the right move, or whether more is required, or whether this is less. And at the end of the day, government took some decisions with some tweaks which were different from what were made as a policy announcement in the beginning. And obviously, we'll get to hear about that as well. And I know it's going to be quite tough, especially for those who will be debating against the motion, because the fact remains that the market has accepted that today, and we are almost into 8 months kind of a implementation of that. And then we haven't really seen a massive protest. But having said that, that it does not mean that there are not opinions against that, or there were not views contrary to what there was. And in fact, some of you who may have seen my statements coming in the public domain, be it on the Instagram, be it on Twitter, be it a piece that I wrote in Financial Express, my views were quite well known, and they were not entirely the way I would have loved to see this happening based on my experience of having seen at least 3 major economic crises in my lifetime. So I am really looking forward to listening to the participants and see how what prism they use to make their viewpoint. And the only thing which I would like them to keep in mind is that that insolvency law is something which sits at the heart of the financial architecture of any country. It's a mother of commercial laws, and therefore this particular law is not really seen to be as something which is adversarial, which is something which affects only the parties that are in contest, but has a much larger role to play in the economic system, in the country system. And let's see how they bring out all those aspects in the debate. Thank you so much, Ayushi, for having me here. It's a pleasure.
Thank you so much, sir, for providing those insights on the motion and the context. I believe the audience would gain tremendously from it. Without further wasting any time, I would introduce the people who have made this insolvency episode of the alternative debate possible, which is our esteemed participants. On the opening government, we have Ms. Pallavi Pratap. Ms. Pratap is an advocate on record and has over 10 years of experience in litigation with civil, criminal, and service related matters. She has represented the state governments in various matters, working along other advocates on record and senior advocates, nationalized banks, insurance companies, etc. She was recently named under Business World's 40 under 40 list, which is again a huge honor. Along with her, we also have Mr. Roshan Santhalia. He graduated from Nalsar University of Law, Hyderabad, after completing his 5-year BA LLB honors program in the year 2011. Subsequently, he pursued a full-time degree in MSc Criminal Justice from Oxford University in United Kingdom, and after returning to his home country in 2012, he set up the Santhalia Law Chambers. He also qualified as an advocate on record at the Supreme Court in 2018, and we are extremely privileged to have you with us, sir. On the opening opposition, we have Mr. Sanjay Bhatt. He is the managing partner of Kesar Das B and Associates, a New Delhi-based corporate and commercial law firm with practice in India and abroad. He has been active in law practice for more than 18 years and has authored many international papers and projects dealing with Indian position on insolvency law and insolvency proceedings. He is also a faculty for the Institute of Chartered Accountants of India on commercial laws and was nominated as a member for the working group constituted by the Planning Commission to recommend measures on India's competition policy for the 11th 5-year plan in June 2006. He's also addressed conferences as a speaker organized by the Competition Commission of India and the annual conference of IPBA held in Sydney in April 2006. We're glad to have you with us, sir. Along with him, we have Ms. Niharika Sharma, who is also an advocate and associate at Kesar Das B and Associates. She is a LLB graduate from the renowned Faculty of Law, Delhi University, and has been in active litigation and advisory practice in the field of corporate and commercial laws for the past 2 years, in particular, insolvency and bankruptcy, company law, debt recovery, and restructuring. She also has an extensive experience of appearing before the National Company Law Tribunal and Appellate Tribunal, the High Courts, and also has argued various cases for notable companies. Moving on the closing government, we have Mr. Drupad Vagani, who is an associate partner at Economic Laws Practice, Mumbai. He works in the banking and finance and as well as insolvency and bankruptcy cases for the firm and has over a decade of experience in several matters relating to banking and financial transactions. He holds an extensive experience in resolution of stressed and non-performing assets and has worked on several matters under the new code. He regularly appears before the company law tribunals, high courts, and Supreme Court. He has also practiced privately for some time and also as an in-house counsel for various banks. Along with him, we also have Mr. Nirman Sharma, who is practicing as a counsel at the Bombay High Court and also appears before the Securities Appellate and Arbitration Tribunals. Before starting his own chamber in 2019, he was a part of the chambers of Mr. Sharan Jagtiani, senior advocate at Bombay High Court. He's also worked with Mr. Sham Diwan, senior advocate in Supreme Court of India, and also at DSK Legal in their Mumbai office. Last but not the least, we have our closing opposition, which comprises Ms. Apurva Jayant. Her practice focuses primarily on rendering on private equity, mergers and acquisitions, and transactions including distressed assets in Luthra and Luthra offices. She assists Indian and international investors as well as target companies with structuring acquisitions and divestment transactions, along with a host of other legal expertise. She has over a decade of experience in executing complex acquisition transactions, including pipe deals and multi regulatory regimes. With this, we also have with her Mr. Atman Shah, who also is a senior associate at Luthra and Luthra Partners. His practice in areas includes mergers and acquisitions and insolvency and bankruptcy, and has an extensive experience in acting for resolution applicants participating in the resolution process. He also has a keen interest in empirical legal studies and has spent some time with the Finance Research Group, where he was involved in understanding the implications of IBC from the perspective of tribunal processes. He was also involved with the group's assessment of estimating courtroom capacity at the NCLT level for handling IBC cases. With such a panel with such illustrious careers and experience in the law, we are glad to have all of you on board. And without further ado, I would like to call upon the first Speaker of the House, the Prime Minister, to begin his speech and present the case on side prop. Hear, hear.
Am I audible? Sorry.
I would like to interrupt you there, Ayushi. We actually need to get the poll done before the first speaker can take the floor.
Yes. The audience are requested to view the poll questions on their screens, which shall now be visible. You're requested to vote on the particular question so that we can record the results and use it afterwards in the debate. As a pointers to the participants, I shall be presenting the timer on my screen for your convenience. As we all know, the speaking time per individual is capped at 5 minutes. In case the other panelists have a POI for the current speaker, they can write POI in the chat box, to which the speaker would answer if he or she wants to take it, and then they can unmute themselves and ask the question. I hope the timer is visible to all the participants.
Attendees, please vote according to your choice.
We shall be closing the poll at sharp 4:42, so I request all the attendees to vote by that time. I would also like to inform the audience that towards the end of the debate, we shall be opening the chat box for questions from the audience, and you can address the same to members of the panel. There will also be a poll towards the end of the debate to get the final opinions of the audience on how the debate transpired. Since a significant amount of people have already voted, without further delay, I would now request the Prime Minister to begin her case. I would start the timer whenever you're ready, ma'am.
I'm ready. Am I audible?
Yes, ma'am, you're perfectly audible.
All right, let's get started then. Good evening, Honorable Speaker, fellow members, ladies and gentlemen. I will put forward my submissions for the first 4 minutes, and the last 1 minute, I will try and accommodate as many POIs as possible. The motion for today is this House believes that the recent suspension of the Insolvency and Bankruptcy Code is unviable in the longer run. I would like to begin this debate with a brief gist of the issues. IBC has been a crown jewel in the reforms that this government has brought about in order to ensure that India gets ranked higher up as far as global economies are concerned, specifically pertaining to ease of doing business. The government has introduced suspension of filing of applications under sections 7, 9, and 10 for any default which is to arise on or after 25th of March for a period of 6 months, which will be increased from time to time. But this is just a stopgap arrangement and definitely not viable in the longer run. The government's decision to stay operations was welcomed by industry, as corporate borrowers thought that they've been saved from unnecessary insolvency proceedings, especially during these times. But the government did not did not suspend initiation of CIRP against the personal guarantors. And as we all know, the case is now sub judice before the Honorable Supreme Court. The primary reason for bringing in the ordinance was to ensure that the good assets of pre-COVID days, which may have become good NPAs now, were not acquired at rock bottom valuations. But for how long? It is not that it can go on for a very long period of time, because the reason, of course, to suspend the IBC provisions was keeping in view the socio-economic intentions, so that lower valuations, assets are not acquired at lower valuations, and that the system does not get choked up as a result of it. Yet one will acknowledge the fact that IBC is used as a tool to restructure stressed assets. It is a tool to ensure that non-performing assets are reduced and that our financial institutions do not expose themselves. The suspension for longer term will only expose them to a higher financial risk. And we've very recently seen some of the major banks not being able to meet up with their requirements and defaulting, PMC and Yes Bank being a case. I would like to reiterate that IBC has been the most effective resolution framework till date, and since its inception in 2016 has been the most important framework that has helped in restructuring of companies. The normal functioning of courts and tribunals, I agree, have not been started again, but the adoption of technology has helped in disposal of cases effectively. Now, every crisis brings in a lot of opportunities, and the intention of the government has been to provide breather to these companies. However, such breathing space has to come with a legitimate expiry date, and the government cannot extend provisions put in place for lockdown period, considering that unlock has commenced in various parts of country and the lives have started to go back to slightly normal ways. If we compare the numbers of insolvency applications which were received in September 2019, there were nearly 13,000 applications, of which 10,800 applications are still pending at admission stage as far as September 2020 is concerned. So what is also important is that IBC framework provides a fresh start to defaulting companies, helping them not in finding out a way to just write off their statutory debts which are there. The extension of the suspension will only lead to companies defaulting on payment of taxes, resulting in huge financial burdens upon the government. The need of the hour is to protect the poor and the downtrodden. I don't see any questions or POIs just now. So let me leave you with Charles Dickens and his starting lines from Tale of Two Cities. It was the best of the times, it was the worst of the times. It was the age of wisdom, it was the age of foolishness. It was the epoch of belief, it was the epoch of incredulity. It was the season of light, it was the season of darkness. It was the spring of hope, it was the winter of despair. Here is an endeavor by the government that the worst of times witness the season of light and spring of hope. Thank you so much. I don't see any queries or questions so far as the chat box is concerned.
I thank you for that insightful first speech, ma'am. That's a great beginning to the debate. Since I don't think there are any questions in the chat box, I would now request the next speaker, the first leader of opposition from side op, to present their case. Here.
Sir, you're muted.
Okay. Am I audible now?
Yes, sir, you're perfectly audible.
So, honorable speaker and honorable members of the session, as far as the position is concerned, in our view, the motion is completely viable and should be continued with for a longer duration of time. And the reasons for that are multifold, and I'll spell out one by one. Now, first of all, IBC was introduced, the code was instituted in 2016. The government has been proactively bringing various amendments from time to time. But most of the amendments which have been brought, some of them were in the help of IBC, some were have rather created more negative impact on the market scenario. Now we have seen that in the preamble of the code, the intention of the government was to create a bond market also in India, which unfortunately government has not done any work so far to create that scenario. Now, consequence of all that was that we don't have much resolution applicants, so to say, in the market, and therefore the most of the plans which have been framed have been on a lower side, and not much recovery rate has been able to be generated from the market. Now, in so far as the IBC is concerned, originally there was no provision of Section 29, whereby certain people were barred from participating in the resolution plus process. This 29A was introduced by the government in the year 2017, to be precise, on 29th of November 2017. And during that time, when this opposed amendment of this statute, we have seen number of MSME, and the most hard-hit people were the MSMEs, where in absence of anyone who is coming forward to buy the asset, most of the companies have gone into liquidation, and the data which is available on the website of the board, which is created for under the IBC, clearly reflects that position, that no viable solution were there in the market, and there were no effective players in the market to buy out all the companies and give a resolution or a survival to the such companies who were under insolvency. Now, in addition to that, we have also seen that COVID has hit very badly to the economy, and this is not only in India. In fact, the whole world has suffered because of COVID, and still the crisis is not over. And therefore, in our respectful view, it would be better for the government to implement this and continue with this amendment for a longer duration of time, rather than restricting it for 6 months or to maximum a year. So we are in fact supporting the motion that it should be made for a longer duration. Now, in addition to that, we have already seen that Reserve Bank of India has already announced number of policy measures which are in the support of the debtor, and therefore these supporting measures definitely should continue. In addition to that, we have also seen that the recovery measures which have been other than IBC, which are there in the statute, such as debt recovery law and securitization, they are very much available. So therefore, why should IBC be not kept for a longer duration time, and specifically the filing of fresh cases, keeping in view the time cycle which is required for revival of the economy? And therefore, we are fully in support of this motion, so to say, that it should be made for a longer duration rather than making it for a short duration. In addition to that, we have seen that the data which has been provided or available shows that in the 3 years of IBC so far prior to COVID, except for big ticket companies, rest of the companies have not attained much valuation as far as the restructuring exercise is concerned. So therefore, we are fully in support of this, and that's what my opposition would be to that extent. Thank you.
I thank you for that speech, sir.
Any questions? I don't see anyone.
If the panelists would like to address a question to the current speaker, the floor is now open. I don't believe there are any further questions. With that being said, I would now like to invite the next speaker, the Deputy Prime Minister, to further the case on site government. Here.
Thank you, Madam Speaker, for introducing me. I would just quickly start with the substantive points, and then, no, I'll in fact start with one of the key rebuttals to what has been said by the leader of the opposition, and then move on to my substantive points. Now, the leader of the opposition pointed out the fact that debt recovery tribunals and arbitrations are still there while insolvency gets suspended. Let me point this out at the threshold level itself, that this is a clear case of comparing apples with oranges. The remedies of DRT and the remedies of arbitration are not at all as sharp as the remedy of insolvency. So, if the case that is being tried to made out by the leader of the opposition is that these remedies are at par, then I would say that this is completely devoid of the reality, because we all understand how 13.2 and 13.4 rigmarole plays itself out in the DRT, in the clogged up DRTs of our country. We all know why the insolvency law was introduced. It was simply introduced because these arbitration decrees and the functioning of the DRTs were not enough to deter the bad faith debtors who were not paying the money. So to that extent, I don't think that that comparison was valid. But anyways, moving on to my substantive as to why it is extremely important that this kind of an amendment is not extended, and this kind of a law is not further extended to any enhanced timeline. And for that, I'll quickly like to talk about 4 substantive points. The most important point, in my opinion, is that there is no way in which you can distinguish a default which is occurred due to COVID and a default which is occurred not due to COVID. Now, you see, what is happening is that because of this kind of an amendment which is come into play, there is a clear case of encouraging the bad faith debtors. The bad faith debtors are today, taking the money and not paying back because they understand that the law does not allow for insolvency anymore. And therefore, how do you address that problem? Because we all know that there are millions and millions of enterprise in the country, and a lot of them are actually using this opportunity to abuse the entire economic system, which is definitely lowering the credit sentiment in the market, and also discouraging transactions in the market. Because today, while giving credit, I as a seller do not have that confidence that if my money is not paid, I have an insolvency court to go to, which is obviously discouraging transactions, and especially credit transactions. So we understand that COVID was once in a million scenario, without a doubt, once in a million year scenario. Without a doubt, it was an unprecedented situation, and it was a situation which definitely required an unprecedented kind of an amendment. But we've got that, and we don't need to extend it, because you see, I mean, why this big talk of new normal? You see, there is this big talk of new normal going on across the world, whether it relates to school, it relates to court functioning, it relates to the way our medical facilities will function. Everyone is adapting to the new normal. Till when can insolvency law be alien to that? Till when can insolvency regime be alien to that? At the end of the day, we have to bite the bullet and move on. And especially now, after the 6 or 7 month period is over. I believe the union lockdown was imposed in March, and that lockdown was for 10 weeks. Obviously, after that, there were some state lockdowns as well. But the larger point that I'm trying to make is that we are definitely far away from the worst, and we cannot keep extending this benefit or exemption of insolvency from the economic system. Now, there is another important point that I want to make, and that point is that how do we determine what date is a good date? You see, vaccine is not in the horizon right now. Till when do we keep extending this? This cannot be a problem in where there is no certainty about when exactly everything will go back to the olden days. And at the same time, when there is no certainty to that, we can't stop our normal lives. We can't stop living our normal lives to a great extent, to an unlimited kind of a time horizon. Now, there is one interesting point also that I want to make, is that voluntary resolution has also gone out of the picture. Now, because of these amendments, what has happened is that not just the operational creditors and the financial creditors cannot trigger insolvencies. The voluntary resolution process is also gone for a toss, which means that if today I as a promoter genuinely feel that my company is not doing well and I want to get admitted into resolution process, I can't do that. So to sum up everything, because I see my time is expiring, to sum up everything, I would say that we've had a good time when this exemption should have been allowed, but there is absolutely no reason why we should not bite the bullet, why we should not go back to normalcy. Until the time we keep evading this, we will keep playing into the hands of malified debtors who will keep abusing this law, thereby depreciating the credit sentiment in the society. Thank you.
I thank you for that interesting speech, sir. If anybody would like to address questions to the current speaker, the floor is again open. And since I believe there are no questions right now, I would now request the next speaker, the Deputy Leader of Opposition, to further their case. Hear, hear.
Good evening, everyone. So I would just like to supplement what Mr. Bhatt has said. The proviso to Section 10A, the amendment in the amendment, it says that no application shall ever be filed for initiation of CIP for a corporate person. So this accounts for an unprecedented situation on account of COVID and lockdown. So this protection has to be given to a corporate person. One cannot assume that every business is not impacted in any way or the other. Because of this crisis, every business is impacted in a way, negatively, majorly. And moreover, a specific time period cannot be decided, cannot be given in such a situation, because one cannot decide as to when the economy can be revived. So one has to give a breather to a corporate person on account of such defaults. I rest my case. Thank you.
I thank you for that speech, ma'am. If there are any questions that panelists would like to ask the current speaker, the chat box as well as the floor is now open. Since I believe there are none, I would now request the first speaker from the closing side of the House to come and further the case on side government. Hear, hear.
Thank you, Speaker. It is with great pleasure and honor for me to address this distinguished forum of honorable members. At the outset, I would like to draw attention of the House that the COVID-19 epidemic is the first and foremost human disaster in 2020. More than 200 countries and territories have confirmed effective medical cases caused by coronavirus declared as pandemic by the WHO. Recent growth rate globally has accelerated to more than 30 million COVID-19 confirmed cases as on 30th September and more than 1 million deaths. Coming back to the impact of the Insolvency and Bankruptcy Code, it is quite palpable in just 4 years of its enactment with its justice-oriented behavioral outcomes. There has been substantial growth and substantial resolution that has happened. We've seen several companies which have been under stress, as there has been a lot of resolutions we've seen. Before I discuss about the outcome, it is worthwhile to say a few words on the effect of the pandemic and across the world. These are unprecedented times when the whole humanity is reeling under the impact of the coronavirus pandemic. It has affected almost every country and every human behaving in planet directly or indirectly. It is not the first time the humanity has seen such a health crisis. There have been several notable epidemics and pandemics in the past century when each of them brought about immense sufferings and economic and social upheavals. I would just like to rejoin to my deputy leader of opposition, to which she pointed out that question that why it should not be further extended. I would just like to highlight one point, that there has been suspension for a period of 6 months. Further suspension of another 3 months will create more troubles, and which has already created trouble for the company, which is already under stress, who wants to come and exit out of this debt which is mounting on a day-to-day basis. Unfortunately, because of the suspension that has been laid down, they are not able to do. as my learned friend has already pointed out, that there has been company who wants to initiate CRP proceedings by initiating Section 10 applications. And just to highlight there, I would like to just draw the stats to that extent, that there has been, out of every application that has been filed under Section 7, 9, or 10, every corporate debtor who wants to initiate, many companies, some very large companies have already initiated resolution under Section 10 since their stakeholders realized that continued operation had become unviable and desired resolution under IBC. Data, this is the data released by the Insolvency and Bankruptcy Board of India, reveals that about 10% of all admitted corporate insolvencies were initiated under Section 10. So that means every company who wants to initiate is been, as of now, has been suspended, who are not able to come out of the debt which is mounting. And unfortunately, this is creating another detrimental issue where, as we all are aware, Section 14 under IBC creates a kind of once the company is admitted under the CIP proceedings, the adjudicating authority prohibits different actions to be taken under, such as your instituting any suit proceedings and all of that. Now imagine a situation that happens that these companies which are unable to initiate proceedings because of the suspension. I am not able to there is no moratorium instituted because there is no CIP initiated, and because of no moratorium initiated, there has been instances where the promoter, see, we'll have to bifurcate this issue into two parts, where the company is genuinely reeling under the IBC, the COVID, and there is company obviously reeling under CIB. There is a possibility of revival, but there are promoters who wants to siphon off the money and wants to enjoy the benefits, which is eventually nothing like not leading to any benefits to the creditors and adding more financial haircuts, which is not the principle, or it's not the true intent and the spirit of the code, because as we all know, the intent of the spirit of the code is to revive the resolution of the corporate debtor, maximization of the assets of the corporate debtor, and provide entrepreneurship. But adding, not giving that suspension, we are not going anywhere. And definitely, in my submission, it is not viable, and it should completely now be withdrawn to that effect. That anyway, as my learned friend has laid down that fact that life has come back to normalcy, things have come back to normal, and there has been instances where only private establishments are shut, but there also there has been 30% things are allowed. But just to add one more thing, that if that suspension is continued, is where Section 10 is the corporate governance is creating another trouble for the company, where a new code, when a corporate debt is in circumstances where it cannot meet its creditor obligation to utilize money for continuing business, it could result in defrauding creditors and diminishing the assets available during the zone of insolvency, which is, again, I would like to say, it's against the principle of this IPC. With that, I will rest my case. Thank you so much.
I thank you for that informative speech, sir. I believe that there's a POI by Mr. Roshan Santhalia.
No, I think I've sent that by mistake. I think he's speaking on my side. So.
Sure, sir. If that is the case, I would like to move ahead and invite the next speaker from side opposition to further their case. Here.
Hi, everyone. Respected Prime Minister, Deputy Prime Minister, members of the Parliament. This question needs to be addressed in the light of the purpose of the IBC and thereafter the purpose of the suspension. What I've heard from the House till now is generally, obviously, emotions on both sides, not necessarily, supported by hard facts. I think the first question is, what is IBC and how does IBC distinguish itself from previous recovery mechanisms? IBC was introduced to create a marketplace for stressed assets. Today, in the world that we live in, existence of a marketplace itself is in question. As you have seen from statistics that keep coming up time and again, India is facing regressive growth rate. Growth rate for India predicted for the next financial year is in fact lower than this financial year, because we're still living off cash that we generated pre-COVID, which will all get exhausted. So today, if you do not have cash in circulation, insolvency is predicated on availability of cash. Today, banks will not find a buyer unless there is cash in the market. And where is the cash in the market? So what you will effectively do by pushing a borrower into insolvency is actually make him wait for 270 days and then push him into liquidation. So unless there is a marketplace, IBC is not an effective tool. This you cannot compare or IBC with your DRT mechanisms. You have to look at if lenders want to find a marketplace, lenders already have a debt restructuring framework, but there is no competitive framework for finding assets. I mean, this is evident from pre-IBC assets as well, because today, if you see Amtech continues to have bidders who do not have cash available to close a transaction. So today, if pre-IBC deals cannot be closed for non-availability of cash, then all you're doing is expediting debt for existing assets by pushing them into IBC. I think the second question that needs to be answered in this context is IBC is at the end of the day a court-run process. Today, whether we like it or not, in order for a court to give an effective remedy, they need to be functioning at optimal capacity. That's not happening. So today, SR Steel took more than 355 days to resolve. So how are you expecting in these COVID times to burden the court in the absence of buyers to be functioning? Third is creditor in possession. Today, one must understand that IBC processes run by creditors come at a cost. Today, which creditor has the ability, with the cash crisis that we have, to take in possession a promoter asset and then run it from there? It is not possible because most companies don't have the cash flow to fund themselves through the CIRP while waiting for their white knight. So whilst you can push the creditor into IBC, we will not even have the cash available on the books of the company to run the company while the CIRP runs. The fourth question here, everybody says now things are back to normal. How are we even saying things are back to normal? You continue to enjoy the RBI relaxations. There continues to be no cross-border trade. You continue to have the spurt in COVID. Most of industries in India cannot work in terms of optimal manpower supply. So how are things back to normal? It appears that the members in the government are only using jargon. We are far. This is no new normal. This is not old normal. We are in the middle of a crisis. And that crisis cannot stem on the fact if you come back to business. Business will take its, if for people who've lived through the 2009 crisis, the crisis doesn't end when you go back to work. It takes a lot more to build back the economy to a situation where there is a solution for the marketplace. Which solution is not going to grow back on the day your lockdown closes. Lockdown has nothing to do with what is the impact of COVID on economy. I think it's a simplistic correlation to say that now that the lockdown is being pulled back, economy is normal. I think the final question today is that I've seen members on the other side say, we want benefit of moratorium. We want to give promoters, ability to get out of their assets. There is nothing that prevents them under law to resolve their debts. They just don't have one and it's not that they don't have the remedy. The remedy has to be exercised by them on a deferred basis. But today, under Indian law, does anything stop a promoter to enter into a compromise with its creditors if it wants to do so? Why does it require the umbrella of IBC? So I think IBC is not a panacea to all problems. To therefore say that today neither borrowers or creditors will find solution merely because IBC is not in place is not the answer. Get back the marketplace and IBC will come back on its own. So the time period has to be linked to growth. Time period for IBC to restart cannot be linked to a regressive growth period. That's all I have to say. Any questions?
I have two questions, if I can.
Sir, please go ahead.
Yeah.
Is it fair for the financial creditors to further bleed by not allowing to initiate proceedings under Section 7 and further take a haircut after suspension is over where there would be value reduction?
No, so
that is my question number one.
Got it. Do you want to
and
ask
my question number two, if I can maybe lay down all the questions, then you can answer.
Right.
And I understand while so Amtech is one of the cases that you just referred during your submission. The Amtech again is one of the case where we have seen the resolution applicant moving out on account of COVID. But there have been other instances that, where resolution plans have been implemented during COVID and where there has been liquidity in the market. So is it again fair for, or is it not right that the plans are being implemented during COVID and fair not to then suspend and then continue with the resolution plan process? That's my question.
Right. So I think the first one is the simpler one to answer. Merely referring a asset to IBC will not create liquidity. Today, you and I will accept that there is no liquidity within the Indian market to pay off creditors. Because liquidity can be originated in three sources: through investor base, so equity and debt. There is no debt in circulation because most creditors have no equity to supply, no credit to supply. That leaves you to go to investors. Today, nobody is going to infuse equity into assets who's not predictable in terms of their future, while they have their own cash flow issues. So merely saying that the cash flow issues of a creditor will be solved by initiation of an application under 7 is simplistic. If a creditor wants to find an M&A solution, he can do so under the stress test mechanism. The reality is, what IBC does is after that put things in autopilot, where if something fails, you go into liquidation. So do that under the voluntary settlement mechanism. But IBC is not a recovery mechanism for creditors. So if it's not available, because that's clear, the Supreme Court has established that, right? So don't treat IBC as a recovery mechanism for creditors. I think on the second question, sorry, can you just repeat your second question? I kind of think I missed it.
So I guess you would you answered to my second question again, but as you were just referring about M&A being a solution or another voluntary insolvency being a solution. All these solutions definitely are there, but another factor that I guess you've missed out on the very basic understanding of IBC is the debt and default. And the purpose of the code being legislated was to maximize the value, which again is my first question, is that tomorrow if the financial creditors wants to initiate proceedings, by not allowing them, you are further bleeding them with not
this is exactly what I'm saying. See, IBC, the purpose is not to enable a financial creditor to recover debt.
But the value reduction,
if you believe IBC needs to be in place to recover debt, then why don't you use the RBI framework? The purpose of IBC is to restructure and maximize profit. So you and I are on the same point when we say IBC is to maximize profit.
What about the value reduction that has happened on account of COVID?
So if there is a value reduction on account of COVID, do you think it's a good marketplace? See, at the end of the day, see an IBC deal as an M&A deal, because effectively IBC in India is translated into resolution of debt by change in ownership, right? Do you see this being a marketplace where there is going to be an M&A deal at good value? What is the liquidation of the value? You're not even going to be finding the right value, right? Because liquidation value in COVID is going to be very different from liquidation value outside of COVID. Fair value in COVID will be very different. So you're actually going to be compelling promoters and creditors to do deals at discounts. So if you want to identify value, then everything else in the economy has to be equal. Today, everything in the economy is depressed. Today you're getting some assets at the value of peanuts. Because, if I had to buy SR Steel today, I wouldn't be paying 50,000 crores. There's no connectivity with any steel plant overseas. Export is stopped. Thermal there's no connectivity. I would buy it for 20,000. So if your focus is valuation, then you have to value the asset when things are good. So then what you should say is, I want IBC, but apply pre-IBC valuation, right? Which the code doesn't enable. So COVID valuation will only not get you white knights, will get you black knights. And if you see, the government per se is in the direction of protectionism, right? We don't want to sell cheap, which is why we don't want China in India today. This is just not a security issue. It was also an economic issue, right? So if the reality is that there will be unreal valuations, depressed valuations, then what valuation is the creditor going to realize in this market? He will anyway sell at a discount.
Ma'am, I also had a quick question, only if you have the stamina left to answer.
Oh, no, I have.
Brilliant. I just have a very quick question on a point that you made. Without the insolvency law being in place, what alternative law do you say is there available for the promoters to resolve their debts? You said that they still have, alternative laws under which they can resolve their debts, but I don't see any law which can allow for multiple debtors to be resolved at the same time by the promoters.
So today, let's look at two kinds of assets, right? Today for a promoter, the purpose of 10 is not to let a promoter get rid of his debts, because his creditors need to find a solution. Today, you to say that 10 should be available because a promoter should be able to decide when he can get rid of the company is counterintuitive, because the rationale for 7, 8, and 10 is protectionism for creditors. So in this market, enabling promoters to decide when to call death on a company while not allowing the creditor to decide would be anomalous. So the government has only acted equally. Now, how does a creditor dissolve? The creditor has to go and compromise with every lender today and take the tougher route, because today, in any case, they have to use the RBI mechanism. Of course, it comes with its complications, but there are also the creditor, the borrower is benefiting from the RBI moratorium. So, on one hand, you can't be enjoying interest rate deferment, and on the other, want to offload your asset at a discount to the creditor. So, if there is no
thank you, ma'am. But my simple point was only this: that what is the mechanism through which a lot of creditors, a lot of debtors can come on a round table and decide it? Because I believe insolvency is the only unique mechanism which gives that.
No, the benefit, you can't say today, because IBC forces consensus more easily, one should force creditors to use this mechanism or give borrowers the benefit of this, right? At the end of the day, maybe the promoter, there are two reasons the promoter would want to sell. Promoter does not have cash to run the company and he wants to do a distress sale. If his creditors are on board, then creditors will negotiate with him under the RBI mechanism. Or second scenario where creditors are not on board, in which case you're actually compelling the creditors to come to a solution, which has never been the purpose of IBC. 10 was not to force creditors to accept a solution, right?
That's
so
the
then
reason
you are saying the government
right. No, thank you. Yeah, thank you.
That's the reason. Just my last point that I would like to put it in my question is, in my speech, I had already referred about how the promoters are siphoning off the money and which is not being beneficial for the creditors. By allowing further suspension, it does not take away the problem, and you are adding more trouble and more worries for the financial creditors.
Is there any empirical data? Because our experience with banks is, at the end of the day, there is nothing which a court in India will step in if there
Empirical
is
data
siphoning
right
of
now
funds.
is the personal guarantee being initiated by the
the mechanism to address
creditors.
siphoning of funds is still in place, right? Today, somebody wants to do a fraudulent transaction, creditor is not left remediless.
SFIO has been more active of late after IBC coming in.
Exactly. So, siphoning of funds, if that is a
exactly
solution,
the promoters
that is
are
the problem.
enjoying the benefits rather the creditors getting the money. With that, I don't have any further question to ask.
IBC is not to fix siphoning of funds. That is not the job of IBC. IBC's job is to restructure. I think we need to see what is the end result of IBC. It is not to fix recovery by creditor or allow promoter to offload asset whenever he likes or stop fights. There is a different legal framework for that. IBC is to enable a marketplace to restructure a non-performing asset. That marketplace does not exist.
I think our queries stand resolved. Thank you, ma'am.
I think the queries are well answered by the current speaker. I would also request the participants to limit the POIs to a maximum of 2, since we're losing out on time for other speakers to present their views. With that being said, I would now request the next speaker to come and present the case on site government. Here.
Thank you for the opportunity, Ms. Speaker, and my members of the House. I have heard all the other members focus sufficiently, I believe, on the language of the provision and the domestic effect. But before I go into the meat of what I propose to say, I want to just make a preface that what has happened from the date when the pandemic came and today, I believe there are 2 or 3 important facts which we need to consider. The lockdown was imposed and the lockdown operated for a substantial amount of time and then was withdrawn gradually. That process is going on across the country. Opening of lockdown has a very important effect on the market sentiment, which is showing today that people are reporting back to their jobs, people are reporting back to their shops, people are reporting back in the malls and every other area or business of their own business. Now, what is important is that today these decisions of passing ordinances is not on a drop of a hat. the government of India has been working with regulators such as RBI, SEBI and other regulators who have been watching the performance from the day the pandemic hit and its effect on the economy. If I don't think anyone can dispute the fact that there were certain sectors which did perform well. Agricultural sector performed well, FMCG performed well, tech performed well. So in that sense, giving a blanket prohibition beyond a reasonable point, it appears to be completely arbitrary. The other aspect which Ms. Apurva said in the opposition, that there are no facts. Let me just produce some facts. FDI from the first half of the pandemic to the second half has been a massive change. From 11.5 billion in June, it has risen to 35.73 billion. Now, what is this an indication of? This is an indication of a very important fact that somebody is watching us. We are an emerging market. The foreign markets are looking at us as opportunities. To say today that we intend to bring as much foreign investment as possible, but not secure them, is a big worry, because foreign investors want security. We cannot tell foreign investors that country will take billions of foreign investment, but will give a blanket protection to defaults. That, according to me, is a big worry for the market sentiment which you are projecting abroad. If what Ms. Apurva said, that look, there is no cash in the market, there are no transactions happening, I do not agree. According to me, such a huge surge in the foreign investment is very important to project to the world. Remember, we are an emerging market. Other emerging markets are going to compete with us to invite foreign investment. Second part, in 2020 financial stability report, where RBI has done a stress test, the NPAs have now reached 14.7%. Now, to give a license to promoters or corporate debtors not to pay further, according to me, is a recipe for disaster. This number was last seen closer in 2000, and now we are reaching the same number because of the blanket protection which was given to the corporate debtors. All that we are saying is that if lockdown has been withdrawn, certain sectors have performed very well, FDI is on the rise, there is cash and market sentiment which is improving. To say that despite all of these positive changes, there should be a blanket protection to corporate debtors, according to me, is a license for committing further defaults. Let the IBC work on its own. It's not as if creditors have no application of mind. When the matter approaches a court of law, please remember it's the wisdom of the committee of creditors. What the committee of creditors may do before or after the IBC should be left to the wisdom of creditors, because market is trying to get back on its feet. And remember, according to me, it is not as if this is the last sort of ammunition which the government of India has. The entire world is grappling with the issue, but we will continuously monitor. We are seized of the situation. Our regulators have a robust mechanism to take care of it. Today, we feel that a sufficient breather has been given to the corporate debtors. We cannot permit them to commit defaults of the public sector banks or other banks which are involved, because that has a domino effect on the entire market. We need to let corporate debtors and business fend for themselves for some more time. Let the economy come back on its track. FDI will continue. And remember, when IBC is inviting resolutions, when foreign investors are showing positive sentiment, we cannot discourage it. For the resolution plans can have support of foreign investors depending on which sector it is. We need to invite foreign investment. We need to project a growth story to the world outside, as opposed to showing that for a year or months together, we are giving blanket protection to our corporate debtors who are in default. That's a story we do not want the world to see. We want the world to see a growth story of the country. I'm grateful.
I thank you, sir, for bringing out those nuances. I believe there was a question in the chat box by Ms. Apurva Jayant, if you would like to go ahead with that.
Apurva, may I request you to repeat it?
No, I haven't raised my question yet. All I'm saying is, the statistics you kind of, presented is quite on par with what the government of India is doing. Today, you can't say FDI has increased in India because there's been a spike of investment. We all know where that investment has gone. If an investment goes to a single conglomerate, that doesn't show that the foreign investment sentiments have improved in India. Because it is, in fact, the horrors of the Jio transactions and the Reliance retail transactions. There has been no spike in foreign investment in India. And if there has been a spike in foreign investment in India, it has actually happened in profitable enterprises. So it's counterintuitive to what IBC wants to do. So today, you've seen only foreign investment outside of geo in pharmaceuticals, in chemicals, all of which have obviously increased as a result of the pandemic. So I just say that, like the government of India, how do you kind of, how can we kind of deal with these facts accurately, right? Because we all know where the FDI is going. So actually, how do you justify this as a spike in foreign investment sentiments?
Well, my answer to that would be that I do not think a foreign investor thinks like a member of opposition. A foreign investor looks at the reports with the IMF reports, it looks at the report of the UN, and it looks at numbers which the RBI gives. I don't think the foreign investor has any sort of prejudice as to where the money is going. The fact is that a foreign investor looking at an India story will see that for the first 3 months of the pandemic, there was a big problem. There was lockdown, and there were laws passed which indicated that all is not well with us. When a foreign investor is looking at growth numbers, when a foreign investor is looking at like lockdown being withdrawn, and a foreign investor is looking at laws being changed and brought back to the normal situation, that's when the confidence of the foreign investor will come. And as I said, this is a situation where we are an emerging market competing with other emerging markets. China has its own set of problems. We need to capitalize as of now to invite foreign investment, because foreign investors don't exit so easily. Once they are in, RBI policies are rigorous enough to ensure that the money stays with Indian promoters to use for some time. It's not specific to any particular entity. Thank you.
I hope that answers your question, ma'am. With that, I would now request the next speaker of the House to summarize the case on the other side and give us some rebuttals. Here.
Sure.
So, good afternoon, dear Parliament members. I will proceed to show how the onus was on the government to support this motion, but the government has failed to do so. The first argument of the government was that this amendment came without an expiry date, and there was no clear indication as to how long this will last. However, the current amendment has a specific upper limit, and currently it is come into effect for a period which is shorter than the upper limit. So the government is amendment comes with a very clear indication as to how long the relief is required and for how long it will last. As members of the government themselves pointed out, the current COVID situation has been of an unprecedented nature. So in this sort of an uncertainty, it is a bit unfair to ask more clarity in terms of timelines as to how long this could last in the amendment, which in any case, to allay any fears as to how long it will last, the amendment provides for this. The second primary point of contention was whether or not the amendment in the present form will be unviable in the long run. There's nothing which the government members have said which supports to the satisfaction of the Parliament that in fact in the long run there will be issues with the amendment. The primary contention of the government members has been that the amendment itself is unviable, which I will explain how the opposition has done to support and justify the need of the amendment. The last thing with the amendment, the last argument by the government was that there's no requirement for a further extension of the current amendment. This was never questioned in the first case. The proposition was whether or not giving relief for a limited period of time to a limited set of people, whether this will have spillover effects in the long run, and whether or not this the introduction of 10A will be unviable in the future. So the arguments of the government to support this, there seemed to be no opposition from our side also on this. So these arguments were more or less futile. Lastly, I'll come to how the opposition has shown that what the effect of 10A has been, what has been the purpose, and how it has taken proportionate steps to achieve this purpose. As rightly pointed out by opposition speakers before me, that there's a clear need to make sure that genuine corporate entities who are not being able to operate because of this unprecedented COVID situation are not pushed into a liquidation process, are not pushed to sell off their businesses at a subpar value to buyers who are looking to profit out of a pandemic situation. It is important to keep in mind that currently there are a large number of businesses, the continuation of which is important for the well-being of the economy as well. Merely showing numbers, merely showing investment at the cost of otherwise viable businesses dying off is also not a good indication to either foreign investors or domestic investors as a good display of a robust economy. The objectives of this amendment have been met by having a clear indication that this relief is available only for a specific period of time. Currently, it has been extended up to 25th December 2020. And there is no indication that if situation improves, that the amendment will keep getting extended. So in the absence of anything to the contrary, I don't see how this is termed as a blanket protection or termed as excessive protection, because on 26th December, if there's a company in the red, if there's a company which is defaulting, if there's a company which is siphoning of funds and is not paying back banks, there is nothing which stops a creditor from initiating IBC proceedings against such companies. Further, the proof of the amendment being successful is in the pudding itself. It has been 6 months since the amendment has been effective. Over these 6 months, as pointed out in the initial part of the debate, there has been nothing, no data or no prominent voices which have said that this amendment has led to a liquidity crisis among the creditors. There has not been any voice from the banking sector itself, which is saying that the suspension of the amendment is leading to an issue that they're facing towards recovering bad debts. Sure, banks today are facing issues in recovery of bad debts, but pointing it out on this amendment would be an incorrect assumption, and therefore it would be incorrect to support the notion which is being proposed by the House. Thank you.
I thank you for those concluding remarks, sir. This being the last speech of the House concludes our debate for the insolvency round. I now request the tech team to restart the poll so that the audience can vote and register their opinions. I also thank all our esteemed participants for providing such great insights on the topic and helping us learn a little more than we did before. With that, I would now request the audience to also address their questions in the chat box if they wish to specifically address it to some particular panelist. And while that is underway, I would request Mr. Sumant Batra to offer some concluding remarks on the debate and what he felt should be included in the government's insight or the opposition's insight.
Thank you so much, Ayushi. So I'll let people vote for a few seconds and then make some observations, unless, of course, you also want to see if there are any questions that the audience had to the participants.
Sure, sir. The audience members have the chat box to address that, and we believe that there will be some questions in the coming few minutes.
So do you want me to wait till the questions are over and then I make some observations, or do you want me to do it now?
So you can continue with your observations while the audience would vote and probably prepare their questions.
All right, very well. So, I mean, I heard all the participants, and I'm happy that all of them had some good input to make in terms of how they think that the motion should be voted on. I just want to share some thoughts again. If I were to don to myself the hat of a parliamentarian and policymaker as to how would I think, and it's not an easy decision to take, because as a policymakers we have to see that that IBC is a law in which the government has invested so heavily in the last 3 years, and it had just taken off. The wheels had just left the ground, and like an aircraft, the IBC was just beginning to sort of take off and gain height, and then suddenly it is asked to be grounded because of the COVID, and to keeping something grounded for long is not good. We all know that even aircraft need servicing as they are grounded, and more they stay on ground, more the cost. And that is why I think the government was very, very keen, would be keen any day to sort of make sure that the period for which IBC shutters remain pulled down is not too long, because the cost of recommencing the IBC machinery is not going to be easy with the delay. The second is that, the insolvency industry that has been set up under the IBC, a huge investment has been made in that. Insolvency professionals, law firms have invested so heavily in setting up departments, hiring lawyers, and then suddenly if there's no work for such a long time, obviously it sort of does no service to the big insolvency industry that the government hopes that the country will have. And all that is also something which the government is mindful that why there is a need to recommence the insolvency machinery. But at the same point in time, the government is also mindful that because of the lockdown and the aftermath of the lockdown, there was definitely a need to provide a respite to the market, to the industry, and also use that opportunity to think deeply about the measures that would be needed in the short term, in the midterm, and the long term to deal with this situation, because it is not just the COVID and the economic crisis. It is also about the ensuing. If you see the geopolitical developments that have been taking place, which have only got aggravated because of the COVID situation, all that also requires various factors to be taken into account for the policy making. And also at the same point in time, the government wanted to make sure that certain measures are put into place to provide some more time or abilities to the MSMEs to deal with the situation. Because even if you were to open the insolvency industry once again, the challenge would be that MSMEs would still struggle, and therefore they needed to. And therefore, as we all know, that a lot of measures were announced by the government, and we also know that there is a special regime for the MSMEs which is in the pipeline. And these are some of the measures that the government would think in order to balance. So it's all a very fine balancing act. Keeping the whole system shut down for too long is not good, but opening it too soon without having adequate measures in place is also not going to be very helpful. And that's why, I do believe that the policymakers will always continue to think. And of course, the entire focus of attention and the channelizing of the energy would be not on filing of fresh cases, but to ensure stabilization of the existing CRP cases, because they would have gone through a massive disruption. And the entire focus would be that you stabilize those at least and preserve the value of those, while of course the new cases can come even in some distant future. Then of course, a lot was said about the fact that there would be a great impact on the resolution applicant market. Yes, of course, the investor distress asset market would have shrunk quite heavily because of this, but at the same point in time, this can be made up by providing an alternate mechanism, and we all would have seen that and heard that the government is working on pre-packs, which are at a very advanced stage, and that is again an alternate mechanism is being offered, because whatever challenges which the investors may feel and the lenders may find, the absence of resolution applicants, they can be made up in the form of pre-packs, where at least the driving seat would not really be the RPs or the lenders, but the debtors themselves, and the debtors will always be able to get hold of better investors than just the RPs, because RPs don't have those kind of incentives in that sense. But my only closing comment would be that we have to realize that the market dynamics work very differently. You know, the market forces find their solutions to almost every problem. Law, parliament, and stakeholders, they all play their own role, but the parliament only provides the conducive ecosystem, the enabling framework. It only shows the path. At the end of the day, it is the market forces which find their way around. And we have, I'm sure, a great confidence in the India's economy, in the Indians entrepreneurs, is our financial system, that the market forces will make sure that even if the insolvency under the industry is reopened after a gap of 1 year, 9 months, or 1.5 years, they will make sure that the whatever loss has occurred is made good in the shortest period of time. And that is the resilience of Indian market and an average Indian entrepreneur. Thank you so much, Ayush.
I thank you for those insights, Mr. Batra. They have significantly contributed in shaping the opinion of the audience, and which brings me to the results of the polls, which I have just received from my tech team. We did a poll before the debate began, as you all know, to gauge what the audience feels about the motion. And in that question, 21% of the people stated that they were not sure about what the motion pertained to. 17% of the people said they were against the motion, which meant that they wanted the ordinance or these kind of measures to continue. And 62% of the people were in favor, which stated that they do not want these kind of measures to continue. After having heard the brilliant speeches from our esteemed participants, the results have shifted significantly, and 19% of the people are still not sure about what the motion might have impacts on. Only 35% of the people now say that they're in favor of the motion, which means that they want these measures to be taken away. And a whopping 45% of the people state that these measures should in fact continue, which means that the opposition was in this round able to persuade the audience to their side of the narrative, and which is why the opposition has the public mandate for now. But I congratulate all the participants, all the debaters, as well as Mr. Batra, who kindly consented to join us and provide such great insights throughout the debate. It has been an extremely beneficial opportunity for not just RML and LU, but all the other people who have joined us from different fields of law. With that, and to add the last bit of fun to the debate, I request all our debaters, only the debaters and not the attendees, to switch on their cameras for a group photograph to serve as a fond memory of the enthralling debate that we had today. I'll do a short countdown to take the picture, and my tech team is on standby. So 3, 2, 1, smile everyone. Thank you, everyone. And before leaving, I think there is one question from the audience. I am sorry to extend the time, but it is directed to Miss Apurva Jain. If you could kindly direct your attention to the chat box.
Thanks, Divyansh. I mean, that's a very valid question. Of course, we've just donned the hat in the debate that we were asked to. Philosophically, I do believe that there are shortcomings of the way in which IBC is suspended. But insofar as operational creditor confidence and financial creditor confidence is concerned, see, IBC cannot be your confidence building measure. At the end of the day, you have to understand every bank is in this situation today because they all took wrong credit decisions. And therefore, to now lose hope in this situation for, mere suspension of IBC for 12 months is... raising the wrong issue as to why IBC should be in place. So I think for creditors, the confidence building measure is really going to be government kind of rationalizing credit raising norms, credit extension norms, relaxing provisioning norms further, and things like that. IBC, at the end of the day, enforcement measures, while relevant, a lot of these creditors are actually bearing the brunt of their past decisions. So to that extent, whilst, of course, sentiments will be low for creditors, it's a big shift from enjoying 3 years of creditor in possession sort of jurisprudence. But I think, there is no easy solution, in that sense. But at the end of the day, IBC was never meant to be recovery mechanism simpliciter for creditor, right? The purpose was higher. And therefore, merely to satiate this requirement, one can't justify reintroduction of IBC. I think reintroduction of IBC is required because eventually a market, like Mr. Patra said, eventually a marketplace will find itself. And so IBC should be back sooner rather than later. But it is definitely not to address creditor sentiments in that sense.
Thank you, ma'am, for answering that question. I think we'll have one last question from Urmika to Mr. Rohan Santhalia.
I did read that question. So I think, you need to appreciate that the moratorium which has been announced under the RBI policy is slightly different from the moratorium which operates under the insolvency law. Now, what the RBI has said that even if a debtor is defaulting during the lockdown period or for that stipulated period, then that particular debtor will not be termed as an NPA. Okay, now that is very different from the trigger under the insolvency law. Under the insolvency law, what is stated is that if a particular debtor has defaulted, then that particular debtor can be taken under the resolution process. So it will be wrong for you to compare the RBI notification with the insolvency regime, because the RBI notification was specifically to the extent that banks cannot classify a particular entity as an NPA because of the default that has been committed. Whereas what the remedy which is provided under section 789 of the insolvency law is very different. That remedy says that if a particular entity is defaulting, that entity can be taken under resolution process. So the RBI circular never covered the insolvency default. So that's why, the comparison might not be apt.